Welcome to BusinessTraining.com. This video module is focused on the Consolidated Omnibus Budget Reconciliation Act. This is our agenda for the video topic today. Please take a moment to review the outline. The Consolidated Omnibus Budget Reconciliation Act, or COBRA, amends the Employee Retirement Income Security Act, or ERISA, the Internal Revenue Code, and the Public Health Service Act. COBRA allows workers and their families the right to choose to temporarily continue the coverage of their group health insurance benefits at up to 102% of the premium of their coverage. COBRA applies to employers with 20 or more employees. COBRA requires a continuation of coverage in the event of an involuntary or voluntary job loss as long as it is not due to gross misconduct, reduction in hours worked, a transition between jobs, a covered employee becoming entitled to Medicare, the death or divorce of a covered employee, or a child's loss of dependent status from a covered employee. In choosing to continue coverage, employers may require the individual to pay up to the full cost of the coverage of the premium with an additional 2% of administrative charge, totaling the 102% premium max. The payment for continuation of coverage is often more expensive than the amount active employees are required to pay because the employer usually pays part of the employee's coverage. The COBRA payment is often less expensive, however, than individual health coverage. COBRA coverage lasts only a limited period of time depending on the situation, which we'll discuss shortly. As stated before, COBRA applies to private businesses, state, or local governments of 20 or more employees. However, it does not apply to federal government plans or church-related organizations. What does COBRA cover? COBRA covers group health plans, which are defined as the arrangement an employer establishes to provide employees with medical care. Medical care, for the purposes of COBRA, includes inpatient and outpatient care at hospitals, physician care, surgery, or other major medical benefits, prescription drugs, and dental vision and care. Life insurance or disability insurance is not considered medical care. An employer must offer identical coverage that is currently available to active employees and families. Individuals are not required to elect COBRA continuation coverage. There are alternatives that should be evaluated that may be best for the individual or their dependents. Special enrollment is one alternative that allows enrollment into other group health coverage than one offered under COBRA. The Health Insurance Portability and Accountability Act, or HIPAA, states that if an individual or their dependents loses eligibility for group health coverage, he or she may have the right to enroll without waiting until the next open season for enrollment into other group health coverages. An employee losing eligibility, for example, may choose to special enroll in a spouse's plan without waiting for the open season for enrollment. Or, a dependent losing coverage under one parent may enroll in the other parent's group health coverage. To have a special enrollment opportunity, the individual or dependent must have had other health coverage when they previously declined coverage in the plan in which they now want to enroll. The individuals must request special enrollment within 60 days of other coverage loss. Another option is for the individual to enroll in an individual health insurance policy. HIPAA authorizes individuals who lose their group health coverage who have had at least 18 months of coverage without a break in coverage of more than 63 days to buy individual health coverage that does not impose a pre-existing condition exclusion period. COBRA rights that are provided under an employer's group health plan must be described in the Plan Summary Plan Description, or SPD. This written document gives information about the plan, what benefits are available, rights of participants and beneficiaries, and how the plan works. Group health plans must issue an SPD within 90 days after an individual first becomes a participant of the group health plan, or 120 days after it is first subject to reporting and discloses provisions under the ERISA. Any material changes to the plan must provide a summary of material modifications, or SMM, no later than 210 days after the end of the plan year in which the changes become effective. If the changes are a material reduction in covered benefits or services, the SMM must be provided no later than 60 days after the reduction has been adopted by the plan. Group health insurance plans must give anyone who is covered under the plan a general notice that explains the COBRA rights. The offered group health plan must be notified of any qualifying events before an individual may continue coverage under COBRA. Who notifies a group health plan is determined by the qualifying event. An employer notifies a health plan within 30 days if the event is a termination or reduction in hours, death of an employee, covered employee becoming entitled to Medicare, or bankruptcy of the employer. The individual notify the health plan after at least 60 days' time, or as dictated by the summary plan description, for a divorce or legal separation, or a child losing dependent status. After receiving notice of a qualifying event, the group health plan must give beneficiaries an election notice within 14 days, which should include all necessary information to understand the coverage, as well as Cobra administrator information. A group health plan may deny a request for continuation coverage. If this happens, the plan must provide notice of the denial within 14 days of receiving the request, and the notice must explain the reasons for denial. Eligible beneficiaries must be given an election period for continuation of coverage of at least 60 days, which starts on the later date of the date of election notice was furnished to the individual or the date coverage would be lost. Each qualified beneficiary of an event may choose to elect their continuation coverage separately and independently. However, a covered employee or spouse must be allowed to elect coverage on behalf of dependent children of or minor child. If a child is born or adopted during the coverage period, they are automatically considered to be a qualified beneficiary and can then be added to the coverage. If continuation coverage under Cobra is waived, the individual must be permitted to revoke the waiver of coverage, as long as the waiver and revocation of the waiver fall within the election period of at least 60 days. The continuation coverage plan would then begin on the date of the waiver revocation. Continuation coverage must be made available for a limited period of time of either 18 or 36 months, depending on the qualifying event. The duration period for a termination or reduction in force is a maximum of 18 months. If a beneficiary becomes entitled to Medicare, they are entitled to a maximum of 36 months of coverage. However, if the qualifying event was an end of employment or reduction in force, but the employee became entitled to Medicare for less than 18 months before that qualifying event, the Cobra coverage is a max coverage minus the months of Medicare coverage the individual had. So, if an employee enrolled in Medicare for 7 months, but was later fired and the qualifying event was a termination, the employee would receive 29 months of coverage, 36 months minus 7. All other qualifying events entitle individuals with 36 months of coverage. An extension of coverage may be authorized for the 18-month period coverage under certain circumstances. A disabled beneficiary will be provided an 11-month extension of the 18-month coverage for a maximum of 29 months. The caveat is that the beneficiaries may be required to pay up to 150% of the premium. A disabled beneficiary must be determined by the Social Security Administration to be disabled at some point during the first 60 days of continuation coverage and must continue to be so during the remainder of the 18-month period of continuation coverage. The disability extension may be terminated if the Social Security Administration determines the beneficiary to no longer be disabled, though the group health plan must give beneficiaries at least 30 days after the SSA's determination to terminate the extension. The second type of extension happens when a second qualifying event beyond the termination or reduction in hours is the death of a covered employee, divorce or legal separation of a covered employee, a child's loss of dependent status, or an employee becoming entitled to Medicare. This may authorize an 18-month extension, making the max period 36 months. This chart describes the different coverage periods for each qualifying event. A group health plan may terminate coverage earlier than the maximum period of continuation coverage for a number of reasons. The group health plan may terminate if premiums are not paid in full on a timely basis, if the employer ceases to maintain any type of group health plan, if the qualified beneficiary begins coverage under another group health plan after electing Cobra continuation coverage, so long as the new plan does not impose an exclusion or limitation affecting a pre-existing condition of the beneficiary, the qualified beneficiary becomes entitled to Medicare benefits after electing continuation coverage, or the beneficiary engages in some type of conduct that would justify the health plan to terminate coverage in a similarly situated participant or beneficiary that is not receiving continuation coverage, such as fraud. If a group health plan terminates coverage early, it must give the beneficiary notice of the early termination as soon as practicable after the decision has been made, and the notice must describe the date and termination of coverage, the reason for termination, and any rights the beneficiary may have under the plan or applicable law to elect alternative coverage, such as a right to convert to an individual policy. Cobra continuation coverage premium charges may not exceed 102% of the premium cost of the plan that is offered to similarly situated individuals covered under the plan. The cost may not exceed 150% for beneficiaries that are receiving the 11th month disability extension. Cobra premium charges to beneficiaries must generally be fixed in advance of each 12-month premium cycle, though charges may be increased if the charge to the plan increases. The group health plan must allow required premium payments to be made on a monthly basis, though some may even allow weekly or quarterly payments. Payment cannot be required to be sent with the continuation coverage election form, though an initial premium payment may be required within the 45 days of date of the election form being sent. Failure to make this initial payment may cause a loss of all Cobra rights. Premium due dates can be set by the group health plan, but the option to make monthly payments must be given, as well as a 30-day grace period for payment of any premium. However, coverage under the plan may be canceled or frozen until full payment is received before the end of the grace period. How does a covered individual file a Cobra claim for benefits? The summary plan description of the group health plan must explain how to obtain benefits and include a written procedure for processing claims. Submitting and filing claims in accordance with the plan's rules will ensure fewer issues with the filing claims. If the claim is denied, a notice must be given of the denial in writing within 90 days after the claim is filed, stating the reasons for the denial and procedures for appealing the denial. Generally, at least 60 days are provided for appeal denial, and a decision on the appeal must be made within 60 days after that. Is the Cobra premium reduction subsidy still available to individuals who have lost their jobs? The American Recovery and Reinvestment Act provided a Cobra premium reduction for individuals who were eligible due to involuntary termination from employment through the end of May 2010. Due to the statutory sunset, the Cobra premium reduction under the American Recovery and Reinvestment Act is not available to individuals who experience involuntary terminations after May 31, 2010. Can an individual receive Cobra benefits while on FMLA leave? No. The Family and Medical Leave Act requires an employer to maintain coverage to an employee under any group health plan while on FMLA leave under the same conditions as if the employee were continuing work. FMLA leave coverage is not Cobra coverage, and FMLA leave is not a qualifying event for Cobra. Cobra coverage may occur, however, after an employer's obligations under FMLA ceases. Is an individual eligible for Cobra if the company closed or went bankrupt and there is no health plan? No. There is no longer a health plan. There is no Cobra coverage. However, if the company continued to run after bankruptcy and still provide a group health plan or another plan is offered by the company, individuals covered under Cobra will be eligible for Cobra continuation coverage. Union members covered by a collective bargaining agreement that provides a medical plan may also be entitled to continued coverage. If you would like more information on the Consolidated Omnibus Budget Reconciliation Act, please go to the Department of Labor website at the following link. Thank you once again for your time and attention, and this is BusinessTraining.com, where you can earn a master's level qualification to make more money.